We're going to now move to liability insurance. And I know a number of you are in school law. And liability insurance. What's liability, what does that mean in general? Liability insurance. Andy?
Who's responsible?
Okay, for what?
Any damages or the accident?
Yes.
Whatever occurred?
Yes. Who's responsible? And there are two different types of torts, and this gets into tort liability. There's intentional torts, and there's unintentional torts. And of course, the word intentional means that's intended, whereas unintended means that was not intended. And you'll remember, perhaps, malice, and of course, we're talking about assault and battery. When we talk about malice, those are intended. Someone intends on harming someone else. Can you remember the difference between assault and battery? Go ahead.
So isn't assault more verbal, where battery was more physical? Or did I have that wrong?
Nope, you're right on target. Usually you think of assault meaning physical, but actually assault is verbal. And battery is physical. Absolutely. And the individual intends on harming someone. Now, here we're talking about employees. We're talking about employees, not students. We're talking employees.
Hi, this is Nevada Injury Attorney Steve Clearman. Welcome to another edition of Elements of Nevada Law. Today we're going to talk about one of the most basic claims that we bring in Nevada, and that is the claim of negligence. The elements of negligence, in other words, the elements that you need to prove in order to prevail in a negligence case in a Nevada courtroom are as follows. Number one, that the defendant owed a duty of care to the plaintiff. Number two, that the defendant breached that duty. Number three, that the breach was the legal cause of the plaintiff's injuries. And number four, that the plaintiff suffered damages. It's important to keep in mind in Nevada negligence cases, as is the case in most negligence cases throughout the United States, in fact probably all of them, that there have to be two components proved in a case. First, you have to prove liability, and second, you also have to prove damages. So unless there are damages in a case, and this is a frequently misunderstood point, unless there are damages in a case, you cannot prevail in a negligence case in Nevada. This has been another edition of Elements of Nevada Law. I'm Steve Clearman.
And he's right on point when he says that it's not just Nevada law. Most states have those same laws. And negligence is the unintended tort liability. The biggest liability that schools assume for their staff is the reporting of child abuse. You all know that as school officials, you are all mandated reporters. If you suspect child abuse, you are to report child abuse. And here in Ohio, where do you report that to?
Child and Family Services.
Yes,
Child and
Child and Family Services. Child and Family Services, definitely. The one thing that you need to hear here is that if an individual teacher, school official, is found guilty of not reporting when they knew, they are going to be held personally liable. The school is not going to shoulder those responsibilities. I will tell you that the school possesses for all of its employees generally $1 million in potential liability loss. So if someone does something stupid, for example, they're not in their gym when individuals are tumbling or whatever you do in the gym, the school is probably, you are probably not going to be held liable, amazingly enough. In Ohio, there's been cases where individuals were not in their supervised area, but they were not found liable, and the school was not found liable. But if someone does something where they are found to be liable, if it's in the scope of their duties, they will probably, the school's liability coverage will probably take care of it. Okay?
2, 3, 4, blue, I do just 4, plus 2, plus 6, 6, I can jump with 4, plus 2, plus 6, round now let's hear 4, plus 2, plus 6, plus 2, plus 6. Oh my God!
Okay.
Oh, goodness, we hope she's okay. Of course, doing cheerleading stuff like that, it's always dangerous.
She said the magic word there, always dangerous. When you look at that situation, the school is probably not going to be held as negligent, particularly if they have trained the young ladies in how to do those kinds of things. And you might know a little bit more about those kinds of things because of your work as an
Yeah,
athletic.
it's in our policy, I can't remember the name of it, for football too.
Yes.
It's eluding me, it's in our, some endangerment, it's not that.
Assumed it's
Assumption of risk. Assumption of risk, I think.
yeah. There's an understanding that it's dangerous. There's an understanding that you could get hurt if you are involved in this activity, and therefore, most likely, the school is not going to be held liable in this circumstance. Not going to be held
It's right in
liable.
front of me.
What's that?
It's right in front of me on the slide.
Yeah.
Assumption of risk.
Yeah.
I'm feeling smart now.
In this situation, you probably see there's nobody in the gym. The question that's going to be asked as to whether or not the school is going to be liable in this circumstance is, where were those students supposed to be? If those students were sneaking out, goofing around, the school is probably not going to be held liable. However, if the school didn't lock the door to this unoccupied space, didn't report these children as being absent from wherever they were supposed to be, the school might be held somewhat accountable. Now, they're not going to be totally accountable. That's a stupid act. And so that's probably going to be on one of those shows. Anyway, so there's comparative negligence, contributory. His actions contributed to his injuries. Now, whether it was 100%, 95%, it might be determined, but there's definitely going to be an examination of contributory or comparative negligence, and there's going to be a determination as to whether or not the school is liable or not liable. One of the situations that I had the unfortunate pleasure of participating in, and I know you've heard this in school law, but I'll repeat it again for those individuals that weren't in school law. I'm superintending, I'm at a basketball game, and a parent comes to me and says, my daughter, we have just used up all the limits of our health care for my daughter's injury, and wanted to know if the school would be able to help with that. And I'm sure you know about the situation. Well, I didn't know about the situation. that caused some problem for that principal who didn't notify me. Because what had happened is, following lunch in this school, we had gym. And there was a desk over in the corner, and there was a puddle of water in the corner. And the little girl went running over, hit the puddle, and smashed her face right into the desk. Pretty serious, extensive surgeries needed to be taken to get her back to whole. And I knew that we were liable. I knew we were responsible. And so as soon as I found out about it, I looked up, and there was an accident report on the situation. It just wasn't told to me. So the point to you folks is make sure that you let others know of specifically major injuries, and consequently from there we processed the claim and took care of the situation.
Most property accidents involve a homeowner's insurance policy or a commercial insurance policy. A homeowner or a landlord or a commercial property manager has an obligation and a duty to maintain a safe premises for those people that are visiting on their properties. If the landlord or the commercial property owner or the restaurant owner fails
Or the
in
school.
that duty, there is compensation for you. Slip and fall cases are a very complex area of the law. People have a multitude of questions when they're injured on somebody else's property. The first thing the person should do is take a photograph of what caused the injury. Or if they're in a supermarket, demand that a report be made. If there's a substance on the floor, demand that it be indicated in the report. If they're injured in a movie theater or any commercial establishment, do not be afraid to contact a manager to let them know that you've been hurt. Because I can assure you that a week later, 2 weeks later, the management is going to deny that there was ever any substance on the floor, and you're going to be blamed for that.
So, aspiring principals, you're doing your duties, and all of a sudden, a student is on the swing set, and the swing breaks, and lo and behold, there's injury. Talk to me about what you'll do.
Person injured child.
What's that?
I mean, are you talking, assist the child that's injured, or assist with
Yeah, we got
contacting
the
who's
very
on the emergency
the
medical?
very first thing we're going to do is we're going to get that child help. We might have to get the EMT there. We might have to get the school nurse there. We might need to do those kind of things. What else?
Or an accident report.
There's got to be an accident report. There's got to be an accident report. And so we fill out the accident report.
A detailed accident, like not
The-
just a.
The more detail, the better. And in today's age with our cell phones, do what the guy suggests. He's telling it for his clients, who might be coming to him in order to get assistance. But for the school, don't just fill out the report. Take pictures. Take pictures of that swing set.
What you want to find out if and when it's been inspected, and how many times, and who did it.
Well, and I think so, but I think there's a step you better do before that.
Should we call the parents?
Better call the parent.
Well,
I know. I'm just teasing. I'm
thinking
teasing.
about the bleacher. I said that bleacher story before.
No, but let's hear this, please.
First year's AD a couple years ago, I go on the away side because my father tells me, he goes, "You better find out if them away bleachers are okay. Anybody inspect those?" I said, "I don't know." So I went and walked them with my maintenance guy in the third row. I step on one, my whole bleacher comes up. I almost go through the whole thing. Game was in 2 days.
Well,
Could you imagine?
oh my. And you were lucky you didn't get hurt.
Oh yeah. I mean, I didn't get hurt. It came
When we
bounced
get,
back up.
when we get into what you'll be doing if you got hurt, but you were lucky you didn't get hurt. And so consequently, yeah, we've got to, what's our inspection records? And have we looked at things? word to the wise, do walkthroughs of your building looking for potential situations. I'm just in the building, I'm in the boys' locker room, and we're looking at something with the principal, and I look over and I see a pencil sharpener. Why a pencil sharpener in the boys' locker room? I have no clue. And it was broken off. And protruding out was a nice little sharp injury waiting to happen. If you were a boy in locker rooms, you know some of the horseplay that might take place where somebody gets pushed and somebody gets impaled on that. And so I told the building principal to make sure that the custodian took care of that immediately. Here's where you would be caught with a libel suit, is if you know that is there, but you don't take care of it. If you don't take care of it. So, build that into your building processes. I expected my building principals once a week to walk their facility and be on the lookout for potential accidents.
That playground thing you were telling us, when you were superintendent, was there a playground at your elementary that, did that get inspected very often?
Well, we had that situation, and a girl was hurt, and in this particular situation, I knew about it, and we were all aware of those kinds of things. The girl did have to have some back surgery, and we knew that we were responsible. The playground was not safe. Following that episode, we did some other types of things. In fact, the building principal took it upon himself to make sure that he and the maintenance person went out there and inspected the equipment, usually about once every other week or something like that, just to verify that it was in good order. And by the way, you can even get certified. He went ahead and was certified as a playground inspector. You have some experience with that?
My mom works for the federal government, Head Start. And so she is a playground inspector
There you go.
for Head Start.
And of course, in the meantime, you can be trained. And now, when you do those kind of things, that's going to reduce the risk of situations in your school, especially if you're now documenting, and you possibly could lower your
What about like when school's closed but people come to the playground? School's not held liable then, are they?
It's going to be a tough call.
That's
If-
private property,
Well, here's the reason I say it's a tough call. If you do not have clear markings that when the school is not in session, you are assuming the risk of any injuries yourself. If you did not have that marking, I would contend you could be liable. If you had it chained or gated, but you didn't have it locked, and no posting of signs, I think you could find yourself liable. So those are concerns that you would want to think about.
That's similar to like the parking lot, park at your own risk for baseball.
Yep,
Put those up so someone gets a foul ball and
yep,
can't come back.
yep.
So it's a similar type of thing.
Yep. And once again, will that take all of the responsibility off of you? Don't know. But at least you're in a better position than if you ignored it completely and didn't have those signs up there. Obviously, the bottom line here is somebody makes the claim. You process the claim. You provide the specific information from the accident report. You maybe provide those pictures. You provide those kinds of things. And the insurance company is going to make a decision whether you are liable or not. Had a situation where a parent called me and related to me that her son was in gym class, and the class had not started quite yet, but the gym teacher was in the vicinity, and some kid sucker punched him, and he had to be treated and sent to the emergency squad. And she basically said to me, I know you have insurance to cover this. What are you going to do? My common response was, I will contact our insurance company, and I will let them know of this situation, and they will decide whether or not we are liable or not. Now, in my mind, I said, we're not going to be liable for this one. And we weren't. So about a week later, 2 weeks later, the lady calls me and she says, well, your insurance company contacted me and took information from me, and then they informed me that your school is not liable. What are you going to do about it? I said, ma'am, I understand that you're frustrated about this, and I understand that your son was an innocent bystander in the situation. However, our policy is that if our insurance company deems that we are not liable, we are not liable. However, have you thought about contacting that parent of the individual who assaulted your child? And have you heard of small claims court? Because you might need to file a claim in order to get reimbursed for those types of things. And she wasn't happy with me, but I didn't hear anything more from her. So there's a specific example. But my advice is always process the claim. Let the insurance company make the decision whether you're liable or not liable.